Hi, I'm April Fearnley from the Spiggle Law Firm.
And I'm Kristen Farr from the Spiggle Law Firm.
Today we're going to discuss what is a hostile work environment. Kristen, can you tell us what that is?
A hostile work environment is more than an unpleasant work environment or a rude coworker or even a mean boss. For a work environment to be illegally hostile, it needs to go beyond minor inconveniences, casual joking, or general rudeness.
So if my boss is condescending and gives me too much work and is rude and swears and is a terrible manager and it's constant, is that a hostile work environment?
Your first question has to be, why is your boss treating you this way? So for purposes of discrimination laws that protect employees from a hostile work environment, the hostility has to be based on a protected class that the Equal Employment Opportunity Commission covers. So age, disability, national origin, pregnancy, race, religion, and sex are the main categories that are protected. So no matter how bad the treatment is, if it's not because you are a member of one of those protected classifications, it will not be illegal harassment.
And when you say the category sex, is that gender?
It can be gender, it can also be sexual orientation.
Okay, so if it's not just general unpleasantness and obnoxiousness of supervisors, can you give us examples of what really would rise to hostile work environment under some of these categories?
Sure. For example, age discrimination. Age discrimination makes comments such as references to retirement or comments about what someone can or cannot do at this point in their career. And age discrimination protects workers over 40, so it has to be directed to older workers in the workplace. So references to like, when are you going to retire, or you're not capable of doing that, that type of thing could be covered under age discrimination.
Could you give us an example of some kinds of the statements you'd hear under like a race discrimination hostile work environment case?
Sure. For race discrimination, using the N-word would clearly fall under that. Putting a noose on someone's workplace, playing into racial stereotypes, like the angry black woman, angry black man, more passive aggressive things like touching hair, that sort of thing could be harassment based on race.
And what would sexual harassment, hostile work environment look like? What if it's like one incident? Is that enough? What does that look like?
So hostile work environment based on sex, this would include any kind of inappropriate touching, sexual comments, persistent asking someone out on a date if they've said no and they're clearly not interested. The frequency really depends on the severity. If your boss corners you in an office and gropes you, one instance would be sufficient for a hostile work environment. But your boss asking you out on a date one time and you say no, that's probably not going to rise to the level of hostile work environment. So the severity and the frequency kind of go together. The more it happens, the less severe it would have to be to create a hostile work environment.
Right, so what if I think I'm in one of these categories, one of these protected classes applies to me, And I feel that I've been subjected to statements, comments, conduct in my workplace because of my class. What do I do?
So first you need to let your employer know that you are being subjected to a hostile work environment. And this is, if it's from a coworker, this would be notifying your manager or going to HR and letting them know. An employer is not going to be liable for a hostile work environment unless they had knowledge of the hostile work environment and then they failed to take the appropriate action to prevent future harassment.
What if I'm afraid that if I make a report internally, they're going to retaliate against me as opposed to the person who's been doing all of this?
It is illegal to retaliate against someone for filing a report regarding hostile work environment. And that would be another claim that you could have against your employer, hostile work environment and retaliation for anything that was done against you.
All right, let's say I've notified my employer. They haven't really done anything about the colleague that's been, consistently, pervasively harassing me on one of these bases. Now what do I do?
So you would go to the EEOC and file a charge of discrimination. And you
What is the EEOC?
The Equal Employment Opportunity Commission.
And how do I do that? What are my options for doing that?
So there are certain time limits to file a charge of discrimination. You have either 180 or 300 days to file that, depending on where you live. And you would first you can complete an intake questionnaire, and the EEOC will schedule an interview with you to kind of talk through what's going on, and from there you would file a charge of discrimination.
Now, do I do that myself, or do I do that with an attorney, or what are my options?
You can do it by yourself or with an attorney, either way.
All right, so once this gets filed, this charge of discrimination, then what happens?
The EEOC will investigate the charge. If both sides are open to mediation, the EEOC also has a mediation program. They will schedule a convenient time for you and the employer to discuss what you want, in ways that the case can be resolved. If it's not successful at mediation, then the EEOC will investigate the claim. First, they will get a position statement from the employer, and then you have the opportunity to submit a rebuttal to the employer's position statement.
Okay, and then what will the EEOC do ultimately?
Most likely, the EEOC will issue a right to sue letter saying that you have the right to bring a lawsuit against your employer in court. They can also make a finding of discrimination, but it's rare that happens. Usually they'll just issue a right to sue letter, meaning that you've exhausted your administrative requirements and you can sue your employer in court.
And you mentioned mediation as part of the EEOC option. What was that you were explaining?
So mediation is a alternative dispute resolution option for resolving the complaint. Usually the employer is not going to take responsibility for anything, but they might either provide compensation or a reasonable accommodation that was requested, or some other non-monetary compensation to resolve the complaint.
I see. So we might resolve this in a mediation process short of litigation through the EEOC process, and I may have an attorney assist me with it if I want to.
Yes, you can have an attorney with you at that point.
Okay, and just one last question I was thinking of. Does it matter if I choose to stay at the company or leave, before I want to pursue the hostile work environment claim? Does it hurt me if I leave and then want to pursue it? How does that affect things?
So you can still pursue a case even if you leave. If you have left because of the hostile work environment, you may have a constructive discharge claim against your employer, which would be essentially the same as if your employer terminated you. So you could make a claim for lost wages for any time that you were out of work, or if you found a job that was making less than your job that you were harassed at, you could recover the difference in pay between those two jobs.